We've been calling each other husband and wife for over a decade. We own property together, and even our families treat us like we're married. But when my partner got injured last year, the hospital said I wasn't legally family. How is that possible? Many people in Illinois think that simply living together for a certain period of time automatically creates a legal marriage. But here's the reality. Common law marriage was abolished in Illinois decades ago. I'm Jeff Hughes, lead attorney at Sterling Lawyers, and in this video, we're going to set the record straight about common law marriage and what Illinois law actually recognizes and how it impacts your legal rights when your relationship ends. Now let's start with the fundamentals. Common law is an informal type of marriage that still exists in several U.S. states. And what it usually means is that a couple has been cohabitating for an extended period of time. They hold themselves out to others as husband and wife, meaning they could even file taxes together, or maybe they just refer to each other as husband and wife wherever they go. But they never had a formal ceremony, and they certainly did not obtain a marriage license. In states that recognize it, common law spouses enjoy the same legal protections as formally married couples, and that includes property rights, spousal support, and inheritance. Now here's what you need to know in Illinois about common law. Our state abolished it back in 1905, and it doesn't matter if you've been together for decades. You could cohabitate for 40 years. You could share everything, but still, legally speaking, you were unmarried unless you obtained a marriage license and had a ceremony. This has been Illinois law for over a century and is consistently enforced by the courts. We recently represented a client by the name of Maria. Now, that's not her real name for this video, but know that her and her boyfriend had lived together for 18 years. They had a joint mortgage. They had shared credit card statements, even hyphenated last names, but they separated, and she expected maintenance. However, without a legal marriage, Illinois law provided no basis of support. It was devastating personally, but the law was crystal clear. Now, when you split up, this is where complications arise. Without a legal marriage in Illinois, separation does not involve divorce proceedings. Now, what that means practically is this. There is no maintenance eligibility. There is no property division under family law. There is no automatic inheritance or retirement rights. Generally speaking, each person keeps the assets that are titled in their name, or they must prove significant financial contributions. Now, untangling all of those shared assets can be very complex. Joint property purchases or commingled finances may require civil litigation to resolve. Now, there is one important caveat. Illinois will recognize a valid common law marriage that was recognized in another state under the full faith and credit clause of the U.S. Constitution. For instance, if you are recognized as common law married while living in the state of Texas, then you relocated here to Illinois, your marriage remains valid here. But simply cohabitating in Illinois creates no marriage rights, and you must demonstrate that you were legally married elsewhere before relocating here. Now, when it comes to children, unmarried parents have full legal rights and responsibilities regarding their children. Now, that means child support, custody determinations, decision-making, parenting time with the children. These all fall under Illinois parentage laws and apply regardless of the parent's marital status. Now, it's very important to note here, a non-biological parent who hasn't legally adopted may have no parental rights despite years of caregiving. So how do you protect yourself? Now, if you're in a committed relationship but unmarried, consider these 4 different protective steps that you can take. First, draft a cohabitation agreement. Now, what it can do, it can set out financial responsibilities, how property is to be divided, and any other expectations that you want to put in there. The second is joint ownership of assets. So all of your assets that are titled, put both names on those assets. All major purchases, do those in both parties' names. The mortgage, the house title, etc., put them in both parties' names. The third is to secure your parental rights, and you need to do this by going through a paternity action. And the fourth, most obviously, consider marriage. If you want to have the same protections as married folks, then you will need to be married. Living like you're married carries no legal weight in the state of Illinois, and that assumption could leave you completely unprotected. If you're in a serious relationship and you want to safeguard your interests, consult with an attorney before things get really messy. In our next video, we will explore how Illinois actually divides assets in a formal divorce, and whose name is on the title isn't always decisive. Click here and I will see you over there.